case 215386. People of the state of Michigan versus Joshua Wilson. This matter is set forth for review date today. Appearances, please.
Felicia Courtright on behalf of the Attorney General's office.
Don Johnson, Neighborhood Defender Services, on behalf of Joshua Wilson.
Mr. Wilson, can you state your name for the record?
Joshua Wilson here.
Thank you. And it's my understanding there's going to be a plea. So please raise your right hand, sir. Can you, I'm sorry, can you show, oh, there you go.
Right hand's raised.
Okay, you swear testimony you're about to give shall be the truth?
Yes.
You can put your hand down. Can you state your name and age for the record, sir?
Joshua Wilson.
Oh, Mr. Curley, no, and you are a U.S. citizen?
Yes, I am.
I have a settlement offer and notice of acceptance indicating that you would be pleading guilty to a huge charge of disorderly person.
Yep.
Which carries a statutory maximum penalty of days. Do you understand that, sir?
Yes, I understand.
There'd be a probationary period of 6 months.
Okay.
You'd have $592 per month for your child support, or any modified amount if it gets modified by the friend of the court. You understand that?
Yes.
Right, has signed this on behalf of the Attorney General's office. Johnson, your attorney has signed this, and you have signed it. He has signed your name. Is that correct?
I couldn't hear nothing you said. I'm sorry. It's a bunch of noise in the background.
Everyone place themselves on mute. Thank you. And
Ramon Johnson, please put yourself on mute. Thank you.
okay.
Okay, I'm sorry. Could you repeat what you said?
Yes, the plea form is signed by Ms. Courtright, by your attorney, Mr. Johnson, and he signed your name with your permission. Is that correct?
Yes, he did.
Do you have any questions about this in any way?
Yes, I talked to Mr. Johnson about it because I'm supposed to leave the country to see my sons in June for 10 days with my daughter. Being on probation, would that affect that in any kind of way?
You'd have to get permission from the court. I oftentimes do. I can't make any promises now, not knowing the circumstances, but I oftentimes do give permission. Ms. Courtright in the probation department will be able to weigh in if they have any issues. So you're just going to have to get permission from the court.
Is that like, do I have to email someone or anything like that?
Your probation agent can let the court know. Okay.
Oh, okay. I guess I'll get information from Johnson. I'm sorry, what?
All I can say now is I can't make any promises to you, but it's not something that I necessarily will deny. Okay.
Yeah, that's fine. Thank you. I really appreciate you.
And is your wish to plead guilty today?
Yes.
And do you agree to plead guilty via Zoom?
Yes, I do.
Sir, do you understand that if your plea is accepted, you will not have a trial of any kind?
Yes, I understand everything.
And do you understand that you'll be giving up certain rights that you'd have if you had a trial?
Yes, I do.
Do you understand that you'd be giving up the right to have a trial by jury?
Yes, I do.
Do you understand that you'd be giving up the right to be presumed innocent until proven guilty?
Yes, I do.
Do you understand that you'd be giving up the right to have the prosecutor prove beyond a reasonable doubt that you are guilty?
Yes, I do.
Do you also understand that you'd be giving up the right to have the witnesses against you appear at trial?
Yes, I do.
And do you understand that you'd be giving up the right to question the witnesses against you?
Yes, I do.
Do you also understand that you'd be giving up the right to have the court order any witnesses you have for your defense to appear at the trial?
Yes, I do.
And do you understand that you'd be giving up the right to not have your silence used against you in any way?
Yes, I understand.
Do you also understand that you'd be giving up the right to testify at the trial if in fact you wanted to testify?
Yes, I do.
Do you understand your constitutional rights?
I do.
Do you have any questions about them in any way?
No, I do not.
Do you understand that if your plea is accepted, you will be giving up any claim that your plea was the result of any promises or threats that were not disclosed to me today, or that it was not your own free choice to plead guilty today? You understand that?
I do understand.
And okay, and do you understand any appeal from conviction and sentence pursuant to your plea will be by what is called application for leave to appeal and not by right? What that means is you have to ask Michigan Court of Appeals to review your case. You wouldn't have an automatic right for them to review your case.
Yes, I understand.
Has anyone promised you anything other than what's been stated on the record today?
No,
Has anyone threatened you or forced you to plead guilty today?
no,
Is it your own free choice to plead guilty today?
it's my own free choice.
And are you pleading guilty because you are in fact guilty to what you're pleading guilty to, sir?
Yes, sir.
Okay, thank you.
No
I'm going to
worries.
direct your attention to the dates of March 1st of 2015 through February 1st of 2021. Were you ordered to pay child support for your child and the amount is ordered by the Wayne County Circuit Court? Is that a yes?
Yes, I was ordered.
And you knew about that order, correct?
Yes,
And did you fail to pay child support for your child pursuant to that order?
I guess yes. Let's just say yes.
Yes.
No, I don't want you to guess. That's not.
Well, I was
Sir.
paying. I sent it to her directly. I missed some payment, so I'm guilty. So let's just say yes. Yes, I did. Yes.
Okay, hold on. That's okay. We don't have to rush through this.
Yeah.
You missed some payments during that period of time. Is that fair?
Yes. Yes.
People satisfied with the factual basis and advice of rights?
Yes,
Defense satisfied with both?
Yes, Judge, I am.
Okay, plea will be accepted. Any objection to immediate sentencing, Ms. Courtwright?
no,
Mr. Johnson, go ahead.
Your Honor, Mr. Wilson is working. He's paying his child support now. I think that he'll be able to complete this without any problem.
Ms. Courtwright, anything on behalf of the people?
none,
Mr. Wilson, you agree to be sentenced via Zoom?
Yes.
Do you, anything you'd like to say, sir?
No.
I will adopt the sentence, well, there's no sentence agreement. Well, there is. I'll adopt the sentence agreement and sentence Mr. Wilson to 6 months probation. You must pay your current monthly support of $592 or any modified amount. You must pay $600 in court costs, attorney fees in the amount of $400, a state fee in the amount of $53, crime victims assessment in the amount of $75, and a $30 per month supervision fee. I will waive any late fees. I want you to focus on your child support. So just pay those when you have over the period of probation.
Could you repeat the I'm sorry to cut you off, sir. Could you repeat? I know I got the 600 to 400. It was another one. What was that? Because I'm trying to write this down so I can remember it.
That's fine. You'll be given an order, but it's
Oh,
$75.
okay, that's fine. Okay, I'm sorry.
Okay, thank you.
No worries.
And you may file an application for leave to appeal your conviction and sentence. If you cannot afford to hire an attorney, the court will appoint an attorney and furnish the attorney with the transcripts and file necessary for you to handle your appeal. Your request for an attorney must be made within 21 days. Wish you the
Okay.
best of luck. Thank you, everyone.
Thank you.
We can do Mr. Polk's case. Mr. Polk,
I'll
are
call you
ready, sir?
Friday, Don.
Mr. Polk? You ready? Mr. Childers
Judge,
is on.
John Linville's a dismissal.
Okay, great. We just have one other case that we have to deal with that had to be adjourned from this morning. So, and then we'll do that. We can call, Mr. Childers is on and Mr. Curley's on.
I'm here, Your Honor.
Thank you. Mr. Curley, you ready?
Yes.
Okay, great. We'll call the case.
Calling case 212790, people of the state of Michigan versus Thurman Chillers. This matter is set forth for final conference today. Appearances, please.
Joseph Curley on behalf of the people.
Your Honor, may it please this honor before the very folk on behalf of Thurman Chillers, who gives his permission and consent to have this same by way of his own. Mr. Chillers, would you state your name for the record, please?
My name Thurman Chillers.
Mr. Curley, have you, there was going to be a no contest plea. Do you have any information on that?
The people would not object if Mr. Chillers would like to plead no contest.
Okay, Mr. Chillers, can you unmute yourself and raise your hand? Right hand. You swear testimony you're about to give shall be the truth?
Yes.
You can put your hand down. Can you state your name and age for the record?
Thurman DeAndre Chillers. I'm 18.
Okay, and you are a U.S. citizen, sir?
Yes.
I have a settlement offer and notice of acceptance indicating that you would be pleading guilty to count 3 in the information, assault with intent to commit great bodily harm less than murder, and felony firearm. Count 8 in the information. The assault with intent to commit great bodily harm less than murder is a statutory maximum penalty of 10 years. The felony firearm is a statutory maximum penalty of 2 years with a 2-year flat sentence in the Michigan Department of Corrections. Do you understand that, sir? You have to unmute yourself, Mr. Chillers. I'm sorry. Go ahead. Shoot. Go ahead, sir. There you go.
I hear you, Your Honor.
Do you understand?
Yes.
Okay, thank you. And all other counts will be dismissed pursuant to that plea. Do you understand that?
Yes.
And I've indicated as a Cobb's evaluation, which means what your sentence would be if you were to plead guilty, and it would be probation on the assault with intent to commit great bodily harm less than murder for 2 years, which will run concurrently at the same time that your sentence for the felony firearm will run. Do you understand that?
Yes.
I have a plea form signed by Mr. Sawyer, the previous prosecutor, Mr. Polk, your attorney, and he has signed your name with your permission. Is that correct?
Yes.
Do you have any questions about this? And this would be a no contest plea. And what that means is, sir, is you, for purposes of civil liability based on what was previously indicated, what that means, sir, is you still have a conviction on your record. It would still have the same result as if you were to plead guilty. Do you understand that, sir?
Yes.
Thank you. Do you have any questions about this in any way? Mr. Childers, do you have any questions about this in any way?
No.
Is it your wish to plead no contest?
Could you repeat what no contest is again?
Yes, it means that it would have the same result as if you were to plead guilty, meaning there would be a conviction on your record for assault with intent to commit great bodily harm less than murder and felony firearm. But for purposes of civil liability, the fact that you've pled no contest can't be used against you in a civil matter. Do you understand that?
Yes. So how long would it follow me?
I'm sorry, sir?
So how long would this follow me?
This will be a conviction for felony firearm on your record and assault with intent to commit great bodily harm. It would follow you for, I don't even think you would be able, maybe the law will change and possibly you could get this expunged, but it will follow you right now for forever.
All right. All right.
Do you have any questions about this?
No, that's it.
Is your wish to plead no contest?
Yes.
Sir, do you understand that if your plea is accepted, you will not have a trial of any kind?
Yes.
Do you understand that you'll be giving up certain rights that you would have if you had a trial?
Yes.
Do you understand that you'd be giving up the right to have a trial by jury?
Yes.
Do you understand that you'd be giving up the right to be presumed innocent until proven guilty? Mr. Chillers, you have to unmute yourselves.
I apologize, Your Honor. I keep muting it. But yes, I hear you.
Do you understand that you'd be giving up the right to have the prosecutor prove beyond a reasonable doubt that you are guilty?
Yes.
Do you also understand that you'd be giving up the right to have the witnesses against you appear at trial?
Yes.
And do you understand that you'd be giving up the right to question the witnesses against you?
Yes.
Do you also understand, sir, that you'd be giving up the right to have the court order any witnesses you have for your defense to appear at the trial?
Yes.
And do you understand that you'd be giving up the right to not have your silence used against you in any way?
Yes.
Do you also understand that you'd be giving up the right to testify at the trial if in fact you wanted to testify.
Yes.
Do you understand your constitutional rights? Sir, do you
Yes.
understand? Do you have
Yes.
any questions? Do you have any questions about them in any way?
No.
Do you understand that if your plea is accepted, you will be giving up any claim that your plea was the result of any promises or threats that were not disclosed to me today, or that it was not your own free choice to plead no contest today? Do you understand that?
Yes.
And do you understand any appeal from conviction and sentence pursuant to your plea will be by what is called application for leave to appeal and not by right? That means, sirs, you have to ask the Michigan Court of Appeals to review your case. Wouldn't have an automatic right for them to review your case. Do you understand that?
Yes.
Has anyone promised you anything other than what's been stated on the record today?
No.
Has anyone threatened you or forced you to plead no contest?
No.
Is it your own free choice to plead no contest?
Yes.
Factual basis, Mr. Curley, will be based on what?
Mr. Polk, would you stipulate to the investigator's report?
So stipulate for the purpose of this, please.
Very briefly, can you give a factual basis?
On October 21st, 2020, in the area of 15429 Oldham in the city of Taylor, Wayne County, Thurman Chillers used a Glock handgun to shoot a Lamar Robinson in the arm and causing a gunshot wound to his arm
And intending to commit great bodily harm.
and intending to do great bodily harm.
People satisfied with the factual basis and advice of rights?
The people are satisfied with the factual basis and advice of rights.
Thank you. Plea will be accepted. We're gonna have an in-person sentencing for a convenient date for you, Mr. Pope. So does April 29th work for you?
Yeah, that's a great idea.
Okay, Mr. Chillers, do you mind letting Mr. Chillers know the number he has to call, 313-22?
I've already provided. it to you.
Mr. Chillers, you gotta call that number that Mr. Pokes provided to you, and you have to be here in Frank Murphy Hall of Justice, courtroom 402 on April 29th, okay, sir?
All right.
Thank you, thank you,
All right.
thank you, Mr. Pope. All right, we can go back and thank you everyone for their patience on the FNS docket. What case did we do?
Yeah, I do.
What case did we do?
What time? APA Sadney.
That's
I
correct.
butchered it. No, I sent you a message. Please check it, the chat.
Okay, Mr. Johnson, you indicated there's a dismissal on a case? You have to unmute.
John Linville.
What's the first case we did? So we'll do that one. Okay. Okay.
Calling case 217777. People of the state of Michigan versus John Linville. This matter is set forth for final conference today. Appearances, please.
Gina Suzanne on behalf of the people.
Don Johnson, Neighborhood Defender Services, on behalf of Mr. Linville.
Okay, go ahead, Mr. Johnson. This is Andy.
Well, I would move to withdraw his guilty plea at this time.
Is the
At
case-
this
Oh, I'm sorry, there was no plea. There was no plea, Judge. I believe the prosecutor just has a motion to dismiss.
Yeah, this time, Your Honor, the people are moving to dismiss the complaint or the information
No objection.
without prejudice.
Case will
No
be
objection.
dismissed. Case will be dismissed without prejudice. Thank you.
Thank you.
Thank you. Judge, I have two pleas on Fletcher Jones 2 cases.
Okay, we can do that?
Your Honor,
Yes.
can, I'm reaching out to the prosecutor we have for Anthony Clark, but I have a doctor's appointment I may need to walk into and Zoom back in, if that's possible.
Are we ready on Clark?
No, we're not ready. I'm reaching out to her now so we can have some discussion and we may be ready when I walk out of the doctor's appointment.
Your Honor, can we do Jones? And I'm gonna email the attorney as soon as we're done with Jones. I hadn't heard from her until today, so can we just finish Jones? There's two cases there, please.
Okay, that's fine. And just so everyone knows, we have an in-person hearing for Mr. Tony
Robinson.
at 3, so we'll have to finish the docket by 3. Okay.
Your Honor, do you want me to come down there as well?
That's your case?
Yes.
Yes,
Okay, and then what courtroom are you in, please?
402.
Okay,
So
great.
We'll do Mr. Jones. Anybody that can be, appreciate if they were here. Thank you.
Thank you.
Calling cases 217225 and 217970. People of the state of Michigan versus Fletcher Jones. These matters are set forth for pretrial today. Appearances, please.
Gina Zazani for the people on both cases.
And Don Johnson, Neighborhood Defenders Services, on behalf of Mr. Jones in both matters.
Mr. Jones, can you please raise your right hand? You swear testimony you're about to give shall be the truth?
Yes.
Okay, you can put your hand down. Can you state your name and age for the record?
Fletcher Jones, 54 years old.
And you are a U.S. citizen?
Yes.
I have a settlement offer on that notice of acceptance indicating that you would be pleading guilty to count 1, failure to pay child support, which carries a statutory maximum penalty of 4 years. There'd be a sense agreement between yourself and the prosecutor's office of 12 months under the supervision of this court. MCL 771.1 subsection 2, meaning if you do what you're supposed to do over the next 12 months, this won't be on your record. But if you don't do what you're supposed to do, this will be on your record. Do you understand that?
Yes.
You must pay $2,400 in arrearages to be paid during the course of the court supervision. $87 to be paid by the 15th day of each month. The first payment is due on April 15th, and $1,356 will have to be paid before the final review date of March 30th, 2023. You understand that?
Yes.
And there'd be a currently monthly support of $63 per month that you have to continue to pay. You understand that?
Yes.
There'll be review dates for July 15th, 2022, January 13th, 2023, and March 30th, 2023. Do you understand that?
Yes.
I have a plea form signed by the prosecutor, your attorney, and he signed your name with your permission. Is that correct?
That is correct, Your Honor.
I have another plea form indicating that you would once again be pleading guilty to failure to pay child support, which carries a statutory maximum penalty of 4 years, with a sentence agreement of 12 months. This is on case 21-7225. The other case is 21-7970. And the sentence agreement on 7225 is you must pay, that you would be pleading guilty to failure to pay child support, statutory maximum penalty of 4 years under the supervision of this court pursuant to MCL 771.1 for 12 months. Do you understand that?
Yes.
There'd be an agreement of you to pay $1,000 in arrears to be paid during the course of court supervision. You understand that?
Yes,
$50 is to be paid by the 15th day of each month against the arrears. Do you understand that?
yes,
The first payment is due April 15th of 2022, and you must pay $600 to be paid before the final review date, which once again would be March 30th of 2023. You understand that?
yes,
You don't have any current support on that case, and so we'll have review dates like the other case of July 15th, January 13th of 2023, and March 30th of 2023. You understand that?
yes, I do.
And there's a plea form signed by your attorney. He has signed your name with your permission and signed by the prosecutor. Is that correct?
That is correct, Your Honor.
Do you have any questions about this in any way?
No, I don't.
Is your wish to plead guilty today?
Yes, it is.
And do you agree to plead guilty via Zoom?
Correct.
Do you understand that if your plea is accepted, you will not have a trial of any kind?
Yes, I do.
And do you understand that you'll be giving up certain rights that you would have if you had a trial?
Yes, I understand.
Do you understand that you'd be giving up the right to have a trial by jury?
Yes, I do.
Do you understand that you'd be giving up the right to be presumed innocent until proven guilty?
Yes,
Do you understand that you'd be giving up the right to have the prosecutor prove beyond a reasonable doubt that you are guilty?
yes, I do understand.
Do you understand that you'd be giving up the right to have the witnesses against you appear at trial?
Yes, I do.
And do you understand that you'd be giving up the right to question the witnesses against you?
Yes, I understand.
Do you understand that you'd be giving up the right to have the court order any witnesses you have for your defense to appear at the trial?
Yes, I do understand.
And do you understand that you'd be giving up the right to not have your silence used against you in any way?
Yes, I understand.
You also understand that you'd be giving up the right to testify at the trial if in fact you wanted to testify.
Yes, I do.
You understand your constitutional rights?
Yes.
Do you have any questions about them in any way?
No.
You understand that if your plea is accepted, you will be giving up any claim that your plea was the result of any promises or threats that were not disclosed to me today, or that it was not your own free choice to plead guilty today. Do you understand that?
Yes, I do.
And do you understand any appeal from conviction and sentence pursuant to your plea will be by what is called application for leave to appeal and not by right? That means, sir, is you have to ask Michigan Court of Appeals to review your case. You wouldn't have an automatic right for them to review your case. Do you understand that?
Yes, I do.
Has anyone promised you anything other than what's been stated on the record today?
No,
Has anyone threatened you or forced you to plead guilty today?
not at all.
Is it your own free choice to plead guilty today?
Yes,
And are you pleading guilty because you are in fact guilty to what you're pleading guilty to?
yes, I am.
I want to direct your attention, sir, to the date on case 21-007970. Dates from January 2016 to January 2017. Were you ordered to pay child support for your child by the Wayne County Circuit Court?
Yes,
And and you were aware of that order, correct?
yes,
And did you fail to pay child support pursuant to that order?
yes, I did.
On case 21-007225, I want to direct your attention from the dates of March 2014 through April 2016. Were you ordered to pay child support for your children by the Wayne County Circuit Court?
Yes,
You were aware of that order, sir?
yes, I was.
And did you fail to pay child support pursuant to that order?
Yes,
People satisfied with the factual basis and advice of rights?
Yes, Your Honor, I have one matter I want to bring to the court's attention.
Okay, 1 second. Defense satisfied with both?
Yes, Judge, I am.
Will be accepted. I'm going to be. Before I hear from you, Ms. Suzanne, that first date we'll put over till, that's a Friday anyways, July 15th. We have to do the review dates on the Wednesdays, every Wednesday. So that would be July, so make sure that those are corrected. July, at least the first one will be July 20th, okay, at 1 o'clock.
Thank you, Your Honor. I'm still getting used to the dates.
I understand. So we'll always have to have a Wednesday, okay? And,
Thank you.
Go ahead, Mrs. Andy. Anything you need to bring to the court's attention?
Yes, I just noticed this as you were going over the agreements. The agreement for file 21-7225. There is a noted that the lump sum should be $600 when in fact it should be $400. I made an error and I let Mr. Johnson know just a few moments ago, and I just want to make a record of that so the court will have the accurate amount.
No objection to that correction, Judge.
That'll be corrected. See everyone, we'll schedule it for July 20th at 1 o'clock. Thank you, everyone.
Thank you.
Thank you.
All right.
You're all set, Mr. Jones. Your next court date's July 20th.
July the 20th.
Right.
Got you. Mhm.
That's your first review date.
Okay, July the 20th. Got you.
All right. Thank you, everyone.
You want to take it back to the 11th or push it to the 18th?
I'm gone first 2 weeks of July.
I'm talking about the January date.
I'm not worried about that.
No, okay.
Yeah, well, yeah. And then on that one, January 11th will be the next date, and then we'll have another new delayed sentence date. Okay, we'll call another case.
Judge, I have a plea ready on Wayne Slater.
Okay, we'll call the case.
Calling case 194855. People of the state of Michigan versus Wayne Slater. This matter is set forth for final conference today. Appearances, please.
Can you get
Gina Susanti on behalf of the people.
Don Johnson, Neighborhood Defender Services, on behalf of Mr. Slater.
Mr. Slater, can you state your name for the record?
Wayne Slater.
Please raise your right hand. Swear testimony you're about to give shall be the truth.
Yes.
Put your hand down. Can you state your name and age for the record, sir?
Wayne Slater, 36 years old.
And you are a U.S. citizen?
Yes.
Can you please, Mrs. Andy or Mr. Johnson, please, while we're doing this, email Shadan, our clerk, who'll put her email in the chat and send us the information. I don't have a copy of the information. Mr. Slater, do you understand that I have a plea form indicating that you would be pleading to count 1, failure to pay child support, which carries a statutory maximum penalty of 4 years. Do you understand that?
Yes.
There'd be a sentence agreement between yourself and the prosecutor's office of 12 months under the supervision of this court pursuant to MCL 771.1 subsection 2. Do you understand that?
Yes.
You must pay $4,200 in arrears to be paid during the course of the court supervision. Do you understand that?
Yes.
$200 must be paid by the 15th day of each month against arrears. Do you understand that?
Yes.
You must make your first payment on April 15th of 2022. You understand that?
Yes.
$100 is to be paid before the final review date, which will be, once again, we have to change these dates, and I understand we'll be doing this. The final review date as of now will be April 14th, 2023, but that'll probably change. You understand that?
Yes.
And you must pay current support of $20. I'm sorry, $12. You understand that?
Yes.
The first review day will be July 20th of 2022. The second one will be January 11th of 2023, and then we'll get a new final review date. You understand that?
Yes.
You have any questions about this in any way?
No.
Is it your wish to plead guilty today?
Yes.
Do you understand that if your plea is accepted, you will not have a trial of any kind?
Yes.
Do you understand that you'll be giving up certain rights that you would have if you had a trial?
Yes.
Do you understand that you'd be giving up the right to have a trial by jury?
Yes.
You understand that you'd be giving up the right to be presumed innocent until proven guilty?
Yes.
You understand that you'd be giving up the right to have the prosecutor prove beyond a reasonable doubt that you are guilty?
Yes.
You agree to be sentenced via Zoom or to be take this plea via Zoom too, correct?
Yes.
Do you agree that you'd be giving up the right to have the witnesses against you appear at trial?
Yes.
And do you understand that you'd be giving up the right to question the witnesses against you?
Yes.
Do you also understand that you'd be giving up the right to have the court order any witnesses you have for your defense to appear at the trial?
Yes.
And do you understand that you'd be giving up the right to not have your silence used against you in any way?
Yes.
Do you also understand that you'd be giving up the right to testify at the trial if in fact
Ye-
you wanted to testify?
Yes.
Do you understand your constitutional rights?
Yes.
Do you have any questions about them in any way?
No, sir.
Do you understand that if your plea is accepted, you will be giving up any claim that your plea was the result of any promises or threats that were not disclosed to me today, or that it was not your own free choice to plead guilty today? Do you understand that?
Yes.
And do you understand any appeal from conviction and sentence pursuant to your plea will be by what is called application for leave to appeal and not by right? What that means is you have to ask the Michigan Court of Appeals to review your case. You wouldn't have an automatic right for them to review your case. Do you understand that?
Yes.
Has anyone promised you anything other than what's been stated on the record today?
No.
Has anyone threatened you or forced you to plead guilty today?
No.
It's your own free choice to plead guilty today.
Yes.
Are you pleading guilty because you are in fact guilty to what you're pleading guilty to?
Yes.
I want to direct your attention to the dates of January 2014 through February of 2019, where you are ordered to pay child support for your children by the Wayne County Circuit Court.
Yes.
And you knew about that order, correct?
Yes.
And did you fail to pay child support for your children during that time?
Yes.
Are you satisfied with the factual basis of advice and rights?
Yes, Your Honor.
Yes.
Defense satisfied with both?
Yes.
Yes, Your Honor. I'm satisfied.
See everyone on July 20th at 1 o'clock. Thank you, everyone.
Thank you.
Okay.
Thank you, Judge.
Okay, we can call another case.
What you got next? Just you guys ready on Nicholas
Judge,
Brown?
just 1 minute, please. On the Slater matter that we just finished, I forgot to ask, Mr. Slater has a tether on. Could that be removed?
Any objection? Whose case is that?
Mrs. Zadney?
I'm sorry, I'm having a hard time hearing. What did you ask?
I asked that the tether be removed from Mr. Slater.
At this time, I have no objections.
It'll be removed.
Thank you.
Okay, what do we have ready?
We could do David Locke. I see him on the screen.
Thank you.
And then, Your Honor, can we do an adjournment for Mr. Clark?
I'm here.
We'll do Mr. Locke.
Calling case 177405, people of the state of Michigan versus David Locke. This matter is set forth for review date today. Appearances, please.
Alicia Courtwright on behalf of the Attorney General's office.
Don Johnson, Neighborhood Defender Services, on behalf of Mr. Locke.
David Locke's here.
Thank you. Okay, I think that we were here previously. Go ahead, Ms. Courtwright.
Judge, I don't know what date we were here last.
I believe it was January 18th, maybe, or no?
I'm not sure.
Oh, I can give you two. We were here, this was a failure to appear.
Yeah, we were last here on 118.
We were here on 118, I believe.
Okay.
I usually take pretty copious notes, but
Well, Judge, the defendant is on probation to pay current support of $299 each month, plus an additional $296 each month towards the arrearage. If we were last here in January, he paid his current plus 909, but he had not paid anything in December or November or September or August. And he hasn't paid anything so far in February or March.
That's not. Go ahead.
Mr. Johnson, go ahead.
Well, Your Honor, I think that $1,800 posted on March 11th.
So that would have covered most of the amount that we had since January, obviously.
And Your Honor, my last review date, I paid, I believe it was $2,000, but they split it, which you guys ended up getting, I believe, about $1,200 of it.
Okay, I have the same note. I have $299. I didn't have the arrears that Ms. Corwright indicated, but I did have a note saying that $900 was paid. So I take Ms. Corwright's statement was what was stated last. But so do you have verification of that, Mr. Johnson?
Judge, I see that the money came and it didn't come until the 16th, but it hasn't been applied because the front of the court is holding it.
Okay.
Is there
a reason why it's not applied, Ms. Corwright? Like why they'd be holding it is because there's other cases?
No, because it arrived at the front of the court on the 16th of March. And if it was a money order or certified check, they wait for it to clear before they apply it to his case.
Okay.
On my end,
Judge, the terms of probation.
Just 1 second. I want to hear from Ms. Corwright. Go ahead.
no problem.
Judge, the terms of probation are for him to pay this money each month, not just the months we come to court. And that's what's happening here. He's owed current support every month. Every month he doesn't pay, he commits this felony again. And your order of probation, which says pay monthly, not when you come to court. I mean, unless he wants to come to court every month. That's what I would ask. That's what I would request if that's what this defendant is going to do.
Judge, it's simply a matter of when he receives the money, he pays it. Not everyone gets paid on a weekly basis. Not everyone gets paid on a bi-weekly basis or even a monthly basis. Sometimes they get paid by the job. I think that's what's happening with Mr. Locke.
Can I speak, Your Honor?
I don't really think there's anything to say. I mean,
Okay.
I understand. Okay, there's Ms. Corwright is right that you have to pay every month, and you're wasting your time. You're wasting a lot of people's time. If you just paid every month, we wouldn't have these review dates. But I'm going to have to put this over for another review date to make sure that you're paying now, because that seems to be, and I agree, that seems to be what is the impetus for you to pay is when you're in court. I also understand that you have paid, not on time, but you have paid. It's not as if you haven't paid anything. So I appreciate that. So we're going to put this over. There has to be a payment for April. There has to be a payment for May. There has to be a payment for June, and we're going to be back here on June 8th at 1 o'clock. If there's anything you'd like to say, Mr. Locke, you can say it, but I don't really think there's much for you to say.
I didn't necessarily believe I agree I got to pay monthly, but the payments, the large amounts of payments that I did make, I thought covered the months from review to review, other than the first couple times I screwed up and they split the payment. I'll make sure it doesn't happen again, and I'll get my payments in monthly.
Okay,
Yeah.
well, that's okay. Go ahead.
Judge, if you want him to have paid for June, can you set the date late in June rather than June 8th?
That's fine. I'll pay it. Don't worry. I'll make sure it's paid so we don't have this problem again.
Well, I mean, I don't mind. Yeah, but it has to be verified, so we can do that. That's fine. I think June 29th will be fine. I think that's my last day before vacation. So 1 o'clock.
June 29th. Thank you.
Thank you. Thank you, everybody.
1 second. Go ahead, Ms. Corwright.
I didn't have anything to say.
Okay, thank you.
Okay, Mr. Locke, June 29th at 1 o'clock, okay?
I'll make sure they're all paid.
All right, thank you.
Thank you.
Anything else? Go. We have, oh, this is Miss Gaten Robinson's case. All right, we'll call Mr. Clark.
Calling case 1-87868. People of the state of Michigan versus Anthony Clark. This matter is set for final conference today. Appearances, please.
Gina Zazani on behalf of the people.
Attorney Phyllis Gaten Robinson on behalf of Mr. Anthony Clark, who is present. Mr. Clark, your name for the record.
Mr. Anthony Clark.
Your Honor, Mr. Clark has provided some documentation to me. This, if the court is aware, this has been a round and round saga because Mr. Clark has these children in his custody. His children's mother is now afraid of potentially being prosecuted for welfare fraud. And so she won't, in fact, admit that in writing so that these arrears can be waived. But Mr. Clark has documentation of the leases for the last years that the children have been with him. He's enrolled the children in school. So we have to find a resolve for this outside of where we've been at, because Mr. Clark is the parent that has custody of the children and has for years. So I just emailed the new prosecutor because I had gone back and forth with our old prosecutor. I just emailed over the new prosecutor literally since I've been sitting in my doctor's parking lot. So I know she has no response. But if we could have a short adjournment so that we could try to figure something out, I can forward her all of the information that Mr. Clark has provided me.
How long do you need?
Do you think, Ms. Zaz, how do you say your name?
Zadney.
Zadney. Ms.
Emphasis on
Zadney,
sad.
okay. Do you think a couple of weeks would be good?
At least, yeah, a couple weeks. I haven't gotten your email yet. I just checked. So if we could have a couple weeks, maybe 2 or 3 weeks, that would help. And then we would have an opportunity to talk.
Thank you.
Let's do April 27th if that works.
Yep.
You said April 27th?
Yeah, does that work at 1 o'clock?
Yes, that works for me.
Yes, Your Honor, I can make that work.
Thank you.
Thank you. Mr. Clark, I'll talk to you soon.
Okay.
Mr. Johnson, you ready on Mr. Brown?
Yes.
All right.
I'm gonna let him pick and tell me which one.
All right.
Calling case 200994. People of the state of Michigan versus Nicholas Brown. Matter is set forth for final conference today. Appearances, please.
Felicia Courtwright on behalf of the Attorney General's office.
Don Johnson, Neighborhood Defender Services, on behalf of Mr. Brown.
Nicholas Brown, sir.
I have a note. I think we were last here, January 18th. There was adjourned for the final conference that there was a potential for an offer of disturbing the peace. Where are we at?
Well, my client owes $3,232.77. He's been trying to come up with the funds to take care of that amount, Judge, so that he can get that misdemeanor. He needs more time. He's trying to process a loan. So I'm asking the court to adjourn it. Given the fact that, you know, if we set a trial, it's just going to be out there in limbo. I'd ask the court to give him 6 weeks he's really trying to get this money.
Ms. Courtwright, obviously, it's up to you how long you want to even leave the offer, potential offer open till. What do you want to do?
Well, at the last hearing, my notes indicate that the defendant was still not paying his current support each month and the arrearage was growing. But at least he started doing that. I'm showing the arrearage that he owes is $3,000.77. That's what I'm showing as of this morning.
Okay, well, that's even better.
So do you, any objection for putting this over?
No,
Thank you.
but he's got to continue to pay current support for that offer to remain open.
I will, ma'am. I'll make sure of it.
Okay, so Mr. Brown, you know what's going on, and just try to get this behind you. There's obviously a potential for the Attorney General's office to give you a misdemeanor. And so if you can do that, that'd be great. So we'll be back here. Let's do May 25th at 1 o'clock, okay?
And the amount apparently is $3,000.77, Mr. Brown.
Okay, sir.
All right.
Thank you, everyone.
Thank you.
Judge. Judge, could we do Ramon Johnson?
Yeah.
Calling case 1-88771. People of the state of Michigan versus Ramon Johnson. This matter is set forth for review date today. Appearances, please.
Felicia Courtwright on behalf of the Attorney General's office.
Don Johnson, Neighborhood Defender Services, on behalf of Ramon Johnson.
Ramon Johnson present, sir.
Date. But I indicated there had to be a evaluation on his employment status. He had to provide income verification. Go ahead, Ms. Courtwright.
Judge, we were last here at the beginning of February. The defendant was originally under an order to pay $300 each month towards his arrearage. Now, I don't remember, based on the original sentence, how that number came to be. The arrearage in this case, though, is in excess of $53,000. The defendant has been making those $300 payments, but at the last hearing, I requested the court to consider an increase. He seems to be comfortably paying the $300 each month. And that's when the court indicated that it wanted to see a paycheck stub for January and February, and he wanted his last tax return, assuming that he would have his 2021 taxes done by now. Maybe he hasn't, but my look at Mr. Johnson's finances show that at least last year he made approximately $38,000. In looking at his credit report, he seems to have very little debt on at least on this credit report. He's comfortably making his house payment without issue, current every month.
Sir, yeah, you have to let Ms. Courtwright finish.
They're showing, well, maybe it's a home equity loan, I don't know. But they're showing some type of mortgage that's being paid every month. So we're asking you to increase this payment. He owes a lot of money, and I don't want there to be a huge balance at the end of probation. I'm asking you to increase it to approximately $450 a month. There is no current support. There hasn't been. So he's just paying the $300, and he's been paying it. But that's why I'm asking the increase. I think the defendant can afford to pay more. This is his debt. He does owe it. So we're asking you to order him to pay more per month on this arrearage, up to $450.
Mr. Johnson.
Your Honor, Mr. Johnson sent me his W-2 and several paychecks. And I'll be honest with you, I am not that adept on the computer. And I have been trying to send these, to forward them, but for some reason, in the manner in which I receive them, it's not a manner that I'm familiar with that I can forward them. So the problem here is not that Mr. Johnson didn't do what you asked him to do. The problem is that I'm struggling with the technology. And so I'm gonna have to find somebody to help me do this. If you want to put over for 2 weeks, I can then have them sent.
W-2 from last year.
Yes, from 2021.
Ms. Courtwright already indicated that he made about $38,000.
Okay, Judge. Well, you said you wanted documentation. He provided me his W-2. He's provided me his latest pay stubs. They're just in a format that I'm struggling to forward for some reason. I mean, I'm able to forward other things. I'm able to forward emails, but I don't know why I'm having this difficulty.
But my only point is that Ms. Courtwright has that information as well. And I mean, that's enough for me if that's how much he's making. Mr. Johnson Mr. Ramon Johnson wants to say something. So go ahead.
Yes, Your Honor. Before this happened, I was working as a armed security guard, and because of the felony placed on me, I no longer had an employment as an armed security guard. So I'm reduced to working, if I can now, unarmed because of the felony status of my case. And the mortgage payment, that's a house in Michigan that we had together with my ex-wife that my name is still on. I don't know why. I don't make any pay. I don't have a mortgage or nothing that I'm making payments on, nothing like that. I live in California now, and my wife now assists me and for me making these payments. That's why I'm able to do it comfortably. It's not because of, yes, sir?
Well, I understand, sir, but when you have $53,000 in arrears, I mean, it's not, I know that's a lot. I mean, this is a lot of money, and it's going to be difficult. But I mean, this is a situation that has been created by, you've created the situation, and I have to make sure that you can pay that. I mean, this isn't $5,000.
Well,
This is,
yeah,
excuse me.
Okay.
$53,000 you haven't paid for your child. I'm not here to judge you. I'm here to make sure that you get that paid. The information that's before the court now is that he's made the payments, which is a good thing. There's a significant amount in arrears. I believe that based on what's been represented in the court today, and I'm sure the same thing that Ms. Courtwright indicated is what Mr. Johnson has, that he has $38,000. That is, and this was supposed to be provided, and Mr. Johnson's indicated that he has them and was going to provide it. I think it's appropriate based on the arrears that he has to pay $450.
Okay.
Can I say something again?
No. Otherwise, this is not going to ever get paid. So we need to increase it. I gave him, I think, more of a break early on, and you're going to have to pay that. We'll come back for a review date. There has to be a payment in April, there has to be a payment in May, and there has to be a payment in June, and we can come back on June 29th at 1 o'clock. Does that work for everyone?
The date works, Judge. I just want to indicate that
Well, I don't make that much.
what he's telling you is that he isn't making what he was making in 2021 prior to this felony. And I think that because he's been paying what you ordered him to pay, now it's almost like he's being penalized because he's been paying regularly.
Well, no, I gave him, I think, a bit of a break with somebody that has $53,000 in arrears. I mean, look, the problem that we have is that we have an enormous amount of arrears that haven't been paid. I understand it's difficult, And he's gonna have to pay that, or else people will spend 5 years on probation and then it just gets closed. I mean, this is a very difficult thing to have to make sure that I understand that, but once again, he needs to start paying more in order to pay down the money that he didn't pay for his child. So I understand the objection. I appreciate that, but I think it's more than fair. If this was, $15,000, I'd agree with you. This is 20,000, I'd probably still agree with you, but this is a lot of arrears.
Well, Judge, I'm looking at a check stub that was for a period of 1 week. And for that 1 week, his net is $181.59. That's what he's currently earning, $181.59 a week. That is take home that he can use to pay this child support. I think the fact that he's been paying the $300 is remarkable. And if you raise it to $450, you're just setting him up for failure.
This is a 2019 case. He made $38,000 last year.
Yes, but that was last year, Judge. He's not making that now. As I indicated, his check for the 1 week was $181.59. That's the net.
And was what he paid last year, was that when he had a security job?
Sir?
Judge, in looking at the employment history that I have for this defendant, he's been working at various security companies going back at least to 2011. Now, the last year of 2021, when I gave you the total of places, the total of money that he made, that was over the course of at least 3 different companies comprised of all that income. So I don't know what source of income Mr. Don Johnson has in front of him, but I have ABM Security Specialists, Advanced Security Corporations, Aegis Security Investigations. Those were the 3 different companies that totaled his income for last year. The year before that, he made approximately $35,000. In 2019, and that was when he was able to do armed security, he made almost $58,000. So the drop in income makes sense. So when he was making more money, he had a lower amount to pay. He's saying now that I thought he had a house payment and it was approximately $1,000. He's saying now he doesn't have a house payment. So I think he can afford the difference.
I agree. I'm sorry to interrupt this, Cora, but I agree with this. He has the ability to make this money. I'm sorry, he does. And he has to pay it. It's going to be $450. Thank you.
June 29th, Judge?
Yes. We'll call the next case.
Mr. Johnson?
Well, I'm not sure who's here. I know that Tony Robinson, which is the probation violation hearing, Mr. Robinson has a difficulty in that he's supposed to be picking up his child from daycare around the time of 3 o'clock. He was under the impression the hearing was at 1. I know he's in the courtroom, and I know that you were trying to get the probation officer. If the probation officer is there, I'd like to proceed with the hearing.
We can do that. Is either the prosecutor's office, Mrs. Andy or Ms. Corright going to be a part of this?
I'm part of it, Your Honor.
Okay.
And I don't know if the probation officer is even here. I told her to come on at 2:50. I didn't know you needed her earlier. So I would have
No,
to
we
call
didn't-
her.
No, this was at 3 o'clock.
Right.
Mr. Robinson has been here at once, so maybe he misunderstood, but this was at 3 o'clock. So.
I can see if I can reach her because I just talked to her a little while ago. I didn't know.
Judge, is there a possibility we could put this over for 2 weeks and then he will know that it's going to be 3 o'clock for sure? I won't press that upon him, and he'll just have to make arrangements for his daughter in 2 weeks.
What is his, excuse me, Don, I'm sorry. What's his next court date on his new case? Isn't that in 2 weeks too? He has a felony firearm and Bridget Hathaway.
Is that on a Tuesday?
I'm not for sure the date of it. I know it's a motion hearing. Madam Clerk, do you know the date of his new case?
I have down that he has a motion hearing on April 22nd before Judge Hathaway.
I mean, I can, what do you want to, what's your recommendation, Ms. Johnson and Mrs. Adney?
Well, Judge, I'm asking the court to.
I know what you're asking, Mr. Johnson. Is there any objection, Ms. Johnson?
It's no objection with me at all, Your Honor. And I meant for the record, I think the probation officer will let you know that the defendant did apologize to her and they did remove him off her caseload. So he does have a new agent now.
Come forward. Okay. So what do you want to do now with the warrant, Ms. Johnson? He's here and I'm going to say something to him, but what do you want to do? Do you want to still have a hearing on this?
I don't believe the agent still wanted to have a hearing on it. I think she just wants the defendant to know you have to be respectful toward people and not talk to them any kind of way. That was her biggest issue.
Mrs. Andy?
Yeah, thank you, Your Honor. I also spoke to the agent and she told me the same thing, that the defendant has since apologized, but I do think that it needs to be impressed upon him. But there's actually two aspects to this warrant. There's the aspect of his behavior, which was threatening and aggressive. And then the second is that he owes court costs and fees that he hasn't been paying. And so I took this as a 2-count warrant. And so
Yeah.
I don't know, maybe he wants to resolve this rather than resetting it for a hearing.
No, I don't want to reset it for the hearing on the first part. If the agent, and I'm going to talk to him about this right now, if the agent is okay, and if Ms. Johnson's okay and you're okay, Mrs. Andy, to dismiss that part of the warrant, and believe me, if there's anything even close to this going forward, he's going to be in jail. If there's any disrespect, sir, whatsoever, can you state your name for the record?
Tony Robinson.
Tony Robinson's here. If there's any indication of any disrespect to these probation officers that quite frankly have a very difficult job having to deal with all types of cases, to have somebody say what you said to her is unbelievable. So it better not happen again. You understand? Mr. Johnson, does he want to admit that he hasn't paid his court costs and fines?
I think he does, Judge, correct? Correct, Mr. Robinson?
You haven't paid your court costs and fines. Do you understand that, sir?
I do.
Okay, I just want you to raise your hand. You swear testimony you're about to give shall be the truth?
Yes.
You can come a little bit closer to that microphone. You understand that you have a right to a hearing on the issue. You can you state your name and age for the record?
Tony Robinson, 43 years old.
Thank you, sir. You understand that you have a right to a hearing within 14 days of the allegations, correct?
Yes.
The only allegations going forward now, and once again, what I said, I mean, don't say anything, be enormously respectful to everybody involved in this case. But right now, there's a claim that you have a current balance of court costs and fines of $2,238, and that you haven't paid, you made some payments, but very, very few payments, and you didn't make a payment in October, December, etc. Do you agree that you have not paid all of your court costs and fines?
I agree.
Okay, plea will be accepted. We'll have a payment plan for that. You have to pay at least $150 a month, okay? Anything from either side?
Your Honor, you should know just so you know, the probation officer is in your waiting room. Okay, you're still in the waiting room? Yeah, he letting you in.
Okay, great, we will,
Oh, there she is.
Mr. Bode? Dan, that we did have a hearing set at 3, so I appreciate you being here earlier. Mr. Robinson has to get his, so why don't Ms. Johnson's indicated what you said. These were very concerning. I told Mr. Robinson before you logged on how troubling this was and how probation agents shouldn't have to deal with what you had to deal with. You have to deal with a lot of different cases, a lot of different people. At the very least, everyone needs to show their respect to you. So it's also my understanding that he apologized and that you at this point are okay with having him go forward, continuing on probation with another agent. Is that correct, Mr. Bose?
Yes, that is correct.
Anything else you want to say?
No, well, I do. Me and Mr. Robinson did talk, and he did ask if he could continue to be supervised by me. And I spoke with RM Robinson, our regional manager, and she just stated to bring it up to the court to let the court decide what the courts wanted to do as far as his supervision.
That's fine, and I respect that, but at the same time, I'm really not involved in who should be supervising. That's kind of more of an internal matter, I think.
Okay.
The department. What do you want, Mr. Bose?
Right now, I think it's okay right now for us to leave it as it is.
I will that's an internal matter for the probation department. I'm not going to get involved in it. I would never indicate what agent should be involved, other than requiring maybe an agent to not be involved for whatever reason.
Okay.
So I think that I'll let the probation department handle it. All right, anything else? We need a new date, or are we good?
No data, no new data here.
But we will need another new date because we're tracking his new case, which is scheduled for April 22nd.
Okay, why don't we, sir, be back here? You can be here via Zoom at 1 o'clock on May 18th, okay? Or we can, do you want to just do, yeah, we can do May 18th. Does that work?
That works.
All right, thank you.
Repeat that date. I'm sorry, I didn't hear you.
May 18th.
Thank you.
And just so that Mr. Robinson is clear, who should he call? Which probation officer?
As of this time, it's Agent Moxel. Mulick. Is it Mulick? I think it's Mulick or Moxel. I'll let him know for sure once we're off.
It's Moxel.
Okay, Moxel,
Okay.
Agent Moxel.
Okay, if one of you could provide him with the phone number so he knows who to call, please. Thank you.
Mr. Robinson asked to say something to the court off the record. I indicated to him that, no, I can't have conversations with individuals off the record. It has to be on the record. Is there anything you'd like to say?
Mr. Robinson, just leave it alone now.
I don't think there's
Okay?
anything you have to say.
Just say thank you and go home.
It doesn't have anything to do with it.
If it doesn't have anything to do with the case, sir, don't worry about it, okay? Thank you.
Thank you.
Thank you, everyone. Okay.
Thank you.
Thank you. Thanks, Mr. Boss.
Thank you,
Thank
Agent
you.
Johnson.
All right, we will call another case. Well, it seems like there's some people missing, so there might be some key cases.
I got a bunch of iPhones.
Well, we have Mr. Wiley, Jolanda Wiley.
Yeah, that's not.
Who are we here? If you are a defendant on a case, please indicate your name.
Lemuel Pat.
Mr. Patton?
Yes.
Your Honor, there was an offer made for Mr. Patton, I believe, and I was not able to speak with him. He didn't return my phone call. So if you could put me in a breakout room, I will talk to him right now.
Mr. Patton? You're gonna go in a breakout room. Which one is that? Which
All right.
one is it? I mean, I don't know.
Trayvon Knox.
There's 3 iPhones. I can't put people in a breakout room if everybody's name is the same.
Trayvon Knox.
Mr. Patton, raise your hand so he knows who you are.
Well, I can't, but the issue is it's Mr. Johnson, the way I put him it just says iPhone.
For everybody to name their device.
So I don't know. You're gonna have to name, everybody that has iPhone needs to name their device. I can't really, do you want to just give him a call, Mr. Johnson?
Mr. Patton? Give me the phone number where I should call you.
Unmute yourself.
Oh, you can't see his picture either, can you?
No, I can't now.
Because the one is.
I can't, but it's still.
Did you get it?
No, Mr. Patton, give me your phone number.
313-784-2366.
313-784-2366.
Correct.
I'm calling you now.
All right.
We're gonna take a 5-minute break. Thank you.
Madam Clerk,
Yes, ma'am.
I called Mr. Knox. He said he doesn't know how to do it, but Mr. Knox has on the gray, what is that, a hoodie and a black hat on his head?
The dreads or, yeah.
I think dreads. So that's Mr. Trayvon Knox. And you have a Joshua Wilson? Did we do him?
We did him already.
Okay, so I think Mr. Knox is my last one.
Yeah, I still need Mr. Jones, Mr. Hubbard, Mr. Harris, Mr. Davis, and Mr.
Somebody named Jolanda Wiley with the Galaxy. He got 2 up there. He got 2 devices going. You see that?
Mhm. The person signed in as Yolanda Wiley. Can you give us your name?
He looking around. He don't hear you. He got his hand raised up. Let's see. Him. Yeah. I don't even know how to make him talk. Look like he's trying though. You. I know. We can't hear you. You're not connected. He don't know how to do it, he said. I don't know who he is.
That last one, they never call, they just. So
Shadon, who is the other guy with the iPhone? Oh, that's the one he talking to.
Yeah, Don is talking to him. That is Mr. Pat.
Now here goes somebody else with another iPhone with a black hat.
Yeah, my name is Derek Burdane, man.
No.
Thank you very much, sir.
Okay.
Can you name your device?
Yes, it's an iPhone.
I know. Can you put your name on it though?
I don't know how.
Let's see.
So I just started where he swore him in. That's where I started the record. He records it anyway, right? So
Yeah, everything's on YouTube.
okay. And in the cloud or whatever they say, it's saved, right?
Yeah, I mean, yeah, everything is live on YouTube, so.
So So if I have to ever retrieve it, I can probably get it from where they started. I'm just used to you calling the case. I know what we're doing.
I'm ready on Patton.
Because it was right behind it in his hand, and they both were taking settlement. So we didn't have before. All I sent over was the conviction of the girls. Conviction of the girls should have been scanned in. Everything was scanned yesterday. What did he say? Yeah. And it was double, it was the same charge on both.
Mr. Knox?
He had two cases. And it was the same charge on both of them. And
Mr. Knox?
I wrote in bold cap letter, larger, with a larger font, he's taking about 7. But I didn't get a.
All right, are we ready on something? Oh, 1 second, we're gonna wait for Shada.
I
Mr.
bet it's-
Johnson, which one would you like to do?
You're not,
If you could call Patton, please.
not connected.
And that's the one I gave you, right?
Mr. Patton's not connected. Is that what you're saying, Miss?
No, Mr. Patton is connected. The one that's in there in the gallery, it says Yolanda Wiley. That person's not, because they can't hear us. And we're trying to get them to tell us who they are, but I don't think they can hear us. We can't connect his.
Right. He has two screens open.
Okay, we'll call Mr. Patton. And figure it out.
Calling case 20-1333. People of the state of Michigan versus Lemuel Patton. This matter is set forth for final conference today. Appearances, please.
Gina Zazani on behalf of the people.
Don Johnson, Neighborhood Defender Services, on behalf of Mr. Patton. Mr. Patton, state your name, please. Mr. Patton, unmute and state your name. Your Honor, I called Mr. Patton on the phone and had a discussion with him. This is a case that I've taken over from Miss Perroni, who, as you know, left on March 18th. Mr. Patton has given me certain information. I need to call the complainant in this case to see whether or not she's willing to go forward with a waiver or a partial waiver of the arrearage. I need an adjournment, please.
Any objection?
No, Your Honor.
How long do you need, Mr. Johnson?
Well, I'd like at least 2 weeks, Judge. If I could have a month, that'd be great.
April 27th at 1 o'clock?
April 27th?
Yep.
Thank you.
Thank you, Your Honor. At this point, I think I'm done. So if there's nothing further you need, I'm going to sign off.
Okay, 1 second. I just want to make sure. Why don't we go through these cases? Just Burdine, are we ready on that one? Whose case is that?
Well, that's mine, Judge.
Case.
Fine.
Yes, Ms. Courtrights. Davis, Jean Davis,
That's mine.
Harris,
I don't have a Harris.
Freeman on failure to appear. We'll deal with that. Is that one right now? Is Mr. Harris here? Is there a Jerome Harris? Is he in here? Is he in the back? Nobody's in the back, right? Do you want to, is there an active warrant for him? So I don't know whose case this is, but it's Jerome Harris. Case number 21-004487. And I have it down for an arraignment for failure to appear. What's that?
He failed to appear in January.
He failed to appear in January, and there was a habeas issue, right?
Yep, January 18th.
And it's
Judge, I saw that it was on the docket. Don Johnson appearing on behalf of Mr. Harris. I tried to contact Mr. Harris. I called the phone number that he had provided us with over a year ago. And I got an automated message that the call could not be completed as dialed. So I was not able to reach Mr. Harris, and I have no information.
Mr. Harris is in the jail.
Yeah, okay. That's what makes sense, because this is an arraignment on the failure to appear,
That jail list we got yesterday?
and he was never brought over
We got 3 guys over there.
for this.
Not child support, just Mr. Harris and then 2 others.
Well, he's in the jail. Is this your case, Ms. Courtright? Do you know?
Is it Harris or Harrison?
It's Harris. Harris.
Is it Cedric Jerome Harris?
No, it's Jerome Harris.
Yeah, I don't see that name in my system.
I have it, Your Honor. I didn't realize this was an add-on.
Okay, no, I understand. Now, unfortunately, he's not here. He's in the jail. How do you guys want to proceed?
Well, Judge, if he's in the jail, I'd like to have them brought as soon as possible. So could we do it?
Tomorrow? Can you log on tomorrow? Or can we,
Um,
we're not able to get
well,
somebody from the jail right now, are we?
We have Edwards at 9 o'clock. We have Judge Edwards at 9 o'clock. I could probably log on by 11 or so.
Do you want to do, Mrs. Andy, can you be here at, we usually start at 9 o'clock and start at 8:50?
I can log on at 8:50. I have Edwards at 9 as well.
Actually, probably be easier because I don't want to be rushed and we might have an issue with getting people here exactly at 9. Why don't we, you think you'll be done by 11, Mr. Johnson?
Yes.
Let's do 11 tomorrow, okay? And can you make sure?
Yeah.
Mrs. Zadney may not agree with me.
I hope we're done by
Anybody hear me?
11.
One second. Are we, and Marcel Hubbard, is that yours, Ms. Courtwright?
Yes,
And then I have Eduardo Jones and.
that's mine.
And Trayvon Knox, right?
Those are both mine.
Okay, well, I don't think we need, thank you, Mrs. Andy, appreciate it.
Okay, thank you very much. We'll see you tomorrow morning.
Hello?
Hi, just one second.
Hello?
Yes, what's your name?
Lemuel Patton?
Okay, you're free to go.
Your next court date's April 27th, Mr. Patton. I'm going to be calling you. All right?
Okay. My audio went out. I didn't hear anything. Okay.
April 27th.
All right.
Okay, let's just go down the list. Derek Burdine.
Mr. Burdine should be here.
Yes, sir. I am here.
We're gonna call the case.
Gonna call the Burdine.
Yeah.
Calling case 210543, people of the state of Michigan versus Derek Burdine. This matter is set forth for review date today. Appearances, please.
Felicia Courtwright on behalf of the Attorney General's office.
Don Johnson, Neighborhood Defender Services, on behalf of Mr. Burdine.
Mr. Burdine, can you state your name for the record?
Yes, sir. Derek Burdine.
Mr. Burdine, did you make the payment you indicated to me you were going to make?
Yes, sir. I sent you a picture through your text message. Got a receipt.
Yeah.
Second, I need the file. 1 second. Okay, can either side update me as to what needed to be done?
Judge, we were last here on February 1st. My notes indicate the defendant was not paying as ordered, which is $300 per month. You set today as a review date. He was to have February and March paid. At that point, he said he had paid $225, and that did show up in the month of February. But I'm assuming that was for January because January was a 0. And so far, March is a 0.
Your Honor, Mr. Burdine made a $250 payment yesterday at the Penobscot building. Of course, it hasn't posted yet. So if you want to set another review date to see whether or not that hits, that would be my suggestion.
Well, he needs to make more regular payments, Ms. Courtwright.
Well, this is another situation, Judge, where we're getting money when they have to come to court. And the order isn't $250 a month, it's $300 a month. The arrearage in this case is in excess of $29,000. Even at $300 a month, it's not going to be paid. So I would ask the court to instill upon him that he has to pay 300 and he has to pay it every month.
I think in some way he's getting a bit of a break for it being 300 a month, but I appreciate it if you just make sure you pay that $300 a month, sir. We're gonna have to keep on coming to court. You're gonna waste your time, you're gonna waste everybody else's time. Just pay this consistently. You have to have a payment in April, you have to have a payment in May, and you have to have a payment in June. Now, if you don't make those payments, then there's gonna be consequences. And you can bet on that. Mr. Corwright, you can write that down in your file. So we'll be back here on June 29th, 1 o'clock, okay?
Thank you.
Thank you.
Judge, I have a client, Gene Davis, who tells me he has no audio. I can call him and put him on my speakerphone. Would you like me to do that?
That's fine, yeah.
Excuse me, this is Derek Burdine.
Yes,
I was trying to make sure I had the right court date down. It was June the 27th,
June
29.
29th. Okay, what time? Sorry. Okay, thank you. June 29th.
Calling case 195513. People of the state of
Davis?
Michigan versus Gene Davis.
I'm putting you on my speakerphone, okay?
For
Let me do
sentencing.
it by speakerphone. Speak up.
Appearances, please.
Alicia Courtwright on behalf of the Attorney General's office.
Don Johnson, Neighborhood Defender Services, on behalf of Gene Davis. Your Honor, Mr. Davis is on my speakerphone. Mr. Davis, state your name.
Gene Davis.
Can you hear him, Judge?
yeah, I think we can go forward with this. Okay, as to the pre-sentence report,
I have not received a pre-sentence report.
well, 1 second. This would have been an old pre-sentence report. The one I have is old. It's so we need a new
She
one.
didn't print the new one for you because it's in,
We have it. How do you want to proceed? We don't have a big, let's see here.
Judge, could you forward the pre-sentence report to me? And could we set a date in 2 weeks?
Why don't we do, Ms. Courtwright, you indicated that you're not going to be here on April 13th, right?
Correct. Actually, that schedule changed. You can set it for April 13th.
Well, actually, no. There was only 4 things on the docket, so I might not be able to do the docket that afternoon.
Well, why, can we do it next week?
Yeah. Because he needs to go over it with him. And we don't have, the dockets that we have, since we're here every week, are a lot less. So let's just put it down next week and we will send the report to you, okay? Mr. Davis, be here at 1 o'clock next week, okay?
Judge, isn't Judge Knapp next week?
No, next week is April.
next week is April, so every Wednesday. at
Okay.
1 o'clock.
So next Wednesday.
Yep.
Okay, do I come down there?
No, you can be via Zoom.
So I'm going to call you, Mr. Davis, and we're going to go over the pre-sentence report. But you've got to be back here on Zoom next Wednesday, all right?
Yeah, April 6th.
April 6th at 1 o'clock, okay?
April 6th at 1 o'clock.
Yep.
And it might be, and if you can figure out a better way to communicate with regards to your iPhone, that'd be helpful. Thank you, sir.
Thank you, Judge. Okay, I'll be calling you, Mr. Davis.
Okay.
Bye-bye.
Ready on Mr. Hubbard? Mr. Hubbard.
Is Mr. Hubbard here, Judge?
Is Mr. Hubbard here? Can I have the file? No, and I said he must be present at a previous hearing, so I think this is gonna be a capious. There was a capious already in December, so we've gone over this.
If you call a judge, I can make a record.
Thank you.
Calling case 212899, people of the state of Michigan versus Marcel Hubbard. This matter is set forth for final conference today. Appearances, please.
Felicia Courtwood on behalf of the Attorney General's office.
Don Johnson, Neighborhood Defender Services, on behalf of Mr. Hubbard. Judge, I tried to contact Mr. Hubbard and his phone is not in service at this time. And I think that we previously tried to send him a letter. So I have no explanation for his failure to appear.
Capious will be issued, bond will be forfeited, he will be remanded upon arrest. Thank you. Well, we can do Eduardo Jones.
Is Mr. Jones here?
Mr. Jones, are you here, sir? There are two people on. What's Mr. Linville? We already did Mr. Linville, right?
Yep.
One of them is Trayvon Knox, Your Honor.
Mr. Linville, we already did, right? What are we doing?
Dismissed.
Wait.
Mr. Linville, I don't even know if you were here. Mr. Linville, your case is dismissed.
Okay, thank you very much, Judge. I appreciate it.
Sorry. Okay, well, we'll just call Mr. Jones and then we can do Mr. Knox. Okay.
Calling case 201504, people of the state of Michigan versus Eduardo Jones. This matter is set forth for final conference today. Appearances, please.
Felicia Courtwood on behalf of the Attorney General's office.
Don Johnson, Neighborhood Defender Services, on behalf of Eduardo Jones. Your Honor, I left Mr. Jones a voicemail. I believe it was on Saturday morning. I have not gotten any kind of response.
Capious will be issued, bond will be forfeited, he will be remanded upon arrest. Thank you. And we'll do Mr. Knox.
Calling case 195506, people of the state of Michigan versus Trayvon Knox. This matter is set forth for review date today. Appearances, please.
Felicia Courtwood on behalf of the Attorney General's office.
Don Johnson, Neighborhood Defender Services, on behalf of Mr. Knox. Your Honor, I tried to call Mr. Knox and his voicemail box was not set up. So I was unable to leave a message and I've been unable to speak to him. Could I have a moment in a breakout room with him for just a couple minutes?
Okay, this is the iPhone? Yep. Okay. Yep, we can do that. This is the final conference. Actually, 1 second. No, it's a review date. I'm sorry. All right. We will take
Thank you.
5 minutes or so. All right. Oh. Very long day.
Madam Clerk,
Yes, ma'am.
we didn't get it. The secretary went through it and she says she does not have it. Can you send it to me? Just on that one docket.
The 9721.
Yes, ma'am, and I'll forward it to them. Please. Okay, email it. Huh?
When I scan it and email it, I'm gonna put it to the MDOC referral line again.
Okay, so is that how you gonna do it?
Yep, I'm gonna scan it to you and them.
Okay.
I don't know how they didn't get it though.
I'm back on Knox.
Alrighty, give them a minute.
Alrighty. Okay, we can call the case.
Calling case 195506, people of the state of Michigan versus Trayvon Knox. This matter is set forth for review date today. Appearances, please.
Felicia Courtright on behalf of the Attorney General's office.
Don Johnson, Neighborhood Defender Services, on behalf of Mr. Knox. Your Honor, Mr. Knox informs me that he made a $120 payment in February and a payment for $125 now in March, approximately 2 weeks ago. Hopefully those have posted. He knows that he's supposed to be paying more, but he's having difficulties because of the felonies that he has on his record. And so he's having a hard time finding employment. He has gotten a motion from the friend of the court to get the state arrearage waived and to get a reduction And he's processing that. They have asked him to provide a list of his prior convictions, particularly prior felonies, because I think they take that into consideration, realizing that employment is harder for felons. So that's where we're at. He has made 2 payments in the last 2 months, but they were for only 120 and 125.
What's the order?
Judge, the order is 200 a month on the arrearage and 100 a month on the current. His total arrearage is $21,000. I'm showing that we got $120 this month, and it was probably a payment that he made in late February. Oh, no, actually, it arrived at the front of the court on March 1st. The defendant has several front of the court cases. That's his number one problem. But yeah, the money that we got arrived at the front of the court on March 1st. So there was, nothing paid in February, nothing in January, nothing in December, November, October, September. The last payment was for $91 last year in August. I mean, we have a current support of 100 a month and it's not being paid.
Well, besides that 120, he's also made a recent payment of 125. Apparently has not posted yet.
Yeah, I do not. That one I don't see, but well, I mean, I don't think it's any justice for the custodial parents if we just keep giving these guys 90-day review dates and they're not paying. I mean, in this particular case, we have 1, 2, 3, we have like 7 months of a bunch of zeros. I mean, I think it's time for a show cause. I think it's time for a warrant.
I understand that. And I agree with that. Okay. My view is that in a case like this, we're going to have an in-person review. He'll have to be in court at the next review date. He hasn't paid for a long time and then has paid a little bit, not what he's supposed to pay. And we're going to have to keep on doing this, but I mean, $125 doesn't cut it. How much is the arrears? 20,000, 21,000?
It's in excess of 21,000.
So what I'm going to do, we can have a show cause. He'll have to be in court at the next date. There has to be a significant payment in April. There has to be a significant payment in May, and we'll have it late May. And that means over the $200 in arrears. And what's the current $100 child support?
Yes.
Max?
Yes.
You have to pay $200 in arrears. You have to pay $100 in current support for April and for May. You have to pay more than that. You have to pay as much as possible. You haven't made payments. And that's, you have $1,000.
I'm paying my, sir. Like I have a felony background, so like it's hard for me to even like I'm sitting there in the paper like I'm struggling with bills. Like if I pay, I'm on the verge of being homeless. Like I don't understand how do I even supposed to pay this? If I was having a hard time paying 100, so 300 is very hard.
So here's I don't really want to get into a discussion with you on this. This is what my job is. I have people 20, 30, 40, 50,000, sometimes 100,000. I have to look at all the situations. These are situations where somebody isn't paying for their kids. It's $21,000 that your kid didn't get. I understand that it's difficult. I understand that it might not be easy for you to pay. To be quite frank, sir, that's really not my problem right now. You have to find a way to pay, and you haven't paid what you're supposed to pay. And so you created the situation. And so you're going to have to figure it out. I hear excuse after excuse. I've been doing this docket, and Mr. Johnson is an outstanding advocate, and I oftentimes agree with him. Same thing with Ms. Courtwright. I sometimes agree with her. But I have been doing this docket for 6 years. I have heard excuse after excuse. as to why parents, usually dads.
Sir, all you have to do is look at my
Sir,
record.
sir, don't interrupt me, please.
Oh, sorry
As
about
to
that.
Why? Well, no, I mean, I'm sorry. People come into court all the time and say they've changed their life. They have a great, getting a much far worse felony record than you have, having a great job. There are jobs out there. There are. The economy is much better than it was. You're gonna have to figure it out. We're gonna be back in court May 25th at 1 o'clock. Make sure you make those 2 payments. There's no other discussion. Thank you. And it's gonna be in person. You're gonna be here in person at 1 o'clock. And make sure you're here. And if you don't pay, then prepare to go to jail. Thank you.
I believe that concludes the docket, Judge. Is that correct?
Yes, thank you.
Thank you. Have a good evening.